So the stuff that I'm going to talk about today came up as a suggestion from one of the members of the association who had these questions. We had a conversation about it, and that led to this. And I was thinking that I shouldn't say who that was, but I don't think Dennis cares if I mention anything about the fact that he called me with a question. So, plus he's not here, so he doesn't know anyway. I mean, he was sitting right there a few minutes ago, and I wanted to. Yeah, see? Yeah, all right. So, how many of you are familiar with Utah Business Magazine? Do you guys get that at all? So Utah Business, I didn't know this until this year, but they will allow law firms to sponsor their industry outlooks. And so what that means is that my law firm spent a bunch of money on Utah Business so that we get advertising throughout the year in that magazine. And then they have like 8 to 10 industry forums where they bring people in the industry together, they talk about it, and then they turn it into an article for the magazine. So the first industry forum that they did this year was in January, and it was on construction. And they gave us, since I'm the construction guy at our firm, they asked me to attend, which I did. They gave me the list of who they were thinking about inviting, and it was pretty much all general contractors. I tried to get some more subcontractors onto it, and then basically I was told, Dana, subcontractors don't pay to put ads in our magazine. General contractors pay to put ads in our magazine, so we want to have these general contractors there. So outside of, I think, Hunt Electric, and I think Hunt Electric was the only subcontractor that was there, so maybe they run ads in Utah Business Magazine on a regular basis. So if any of you would like to be able to participate in that forum each year, you can advertise more in Utah Business Magazine. This isn't a pitch for Utah Business Magazine, but it's just a lead into part of what we're doing here. And it's because I don't know if I can keep this going until people's wives get back, so I'm just trying to stretch it out as much as I can. Oh, look who's here. It's Dennis. Hey, Dennis. Nice of you to show up. It's all right. We finished talking about you a while ago. So the whole subject of that discussion, it was 2 hours. It was at our office in Salt Lake. And the whole discussion involved this and everything that you guys have been dealing with throughout COVID and somewhat prior to, but especially since the election, which is labor, supply chain, material price changes, and everything like that. And ultimately, after 2 hours of discussion, what it really boiled down to is that everybody's got to work together. That until something changes, that we get back to a point where labor, the cost of labor, the availability of labor, the cost of materials, the availability of materials becomes somewhat more predictable, then there are a lot of different things that can be done, but ultimately what has to happen is that people have to talk and people have to communicate. And so one of the questions that was raised, particularly for me and the other attorney who were in that meeting, who was Oakland's general counsel, it was, does a contract even mean anything anymore? And my response to that was that the answer is yes, but not in the way that we think. What's happened, especially since, like the late 80s, 90s with WordPerfect and word processing and personal computers, is that instead of having to pay a secretary to sit down and type up an agreement, which is somewhat more laborious than hitting the print button on your computer, the contracts have gotten bigger, they've gotten longer, the print's gotten smaller, and you guys have all seen them, you know what I'm talking about. And so, in the eyes of the law, a contract is a bargained agreement. The whole idea that contract law rests on, and contract law is the law of promises. And I know that before I went to law school, if someone was talking about a contract, I was just thinking about it's a piece of paper that you sign. As an attorney, and in the eyes of the law, a contract is an offer that's accepted, that there's consideration that goes back and forth between the parties, and that the parties are competent. So if you have competent parties, consideration, offer, and acceptance, you have a contract, even if it never gets written down. It might be hard to prove, right, because people have different memories, but you can have a verbal contract. But that idea of offer and acceptance are important because that's where the bargaining goes on. And I think everybody in here probably agrees, especially in commercial construction, but it applies in residential too, where we've gotten into contracts or forms and you just sign my form and you do my job, right? There's not really any bargaining as far as the terms of the contract go. Your bid maybe, so there may be some price stuff with it, but as far as the actual language in the contract, how much bargaining, how much discussion goes on about that? It's just, your bid's accepted, here's the contract, sign it, right? Does everybody agree with me?
And don't mark it up.
And don't mark it, yeah. Well, and that covers the spectrum too. I've spent a lot of hours on the phone in the last year with some general contractors making substantial revisions to their contract, and I've been told by others, such as Leighton Construction, we might change one or two things, but we're not going to do as much as you marked up in our contract, Dana. So that's really where we're at, right? So that's why my comment was, when that question was asked, does a contract mean anything? I said, we've gotten into this idea that contracts are forms, and not the idea that contracts represent bargaining, that it represents a relationship, that it represents an arm's length agreement that people have come to decide how the work is going to be done. And so because of the environment that we're in right now, there has to be, the relationship becomes a whole lot more important, because the ability to have confidence about the price of labor and material, the availability of labor and material over the span of a construction project is much lower than it used to be. So are we all in agreement with that? So the first rule of what we're talking about in the environment that we're in right now is relationship and communication. We can put a lot of stuff into contracts, and everything I'm going to show you here are different ways of contracting, or different ideas for contracting in different types of aspects and stuff like that. We can put all sorts of things into a contract. But no matter what the contract says, we can't change the laws of physics. We can't create more time. We can't change the physical dimensions of a building and things like that. We can't control the economy. We can't control global and local economic effects and things like that. And so because there are so many things that are farther beyond control, then the ability to work within a relationship to deal with that becomes so much more important. So at a minimum in this construction forum, everybody gave lip service to that. But the other thing is that everyone had been affected by it. The developers acknowledged it, the general contractors acknowledged it, everybody acknowledged that things were difficult. One of the companies that was there that does a lot of material supply and subcontracting, they were talking about how they had to get their project managers together and sit down and have a conversation with them, because some of them were refusing to go back out on the projects because they were tired of getting yelled at. because they were tired of being told by project managers for the generals, get me more guys, get your stuff here, do this, do that. And they just basically said, we're tired of being asked to do the impossible. And in fact, one of their guys had a heart attack because of the stress, and he quit. So, and I don't think that what I've just described there is unique to that company. I think you individually or within your companies, you guys have probably all seen that sort of thing, right? So, so no matter what we talk about here today, as far as what we can put in a contract, the important thing is that you communicate as much as possible, especially up front, and that you do as much as you can to help keep people aware of stuff as the job goes on. Because what may be happening today as far as price and availability and your labor force goes may not be the same next week, next month, and so forth. So that's I wanted to start with that just because as an attorney, I can help you understand what to put in an agreement, but I can't help you collaborate on your agreement. And you guys know a lot more about what's going on in your business and what's going on the project. And so that aspect of managing the relationship, the owner-general contractor relationship, the subcontractor, the general contractor relationship, actively doing it, trying to stay ahead of things, recognizing problems and stuff as they come up, or seeing them and trying to deal with them before is of maximum importance right now. Okay, any questions on that before I go to this? Should we just be done? And then I can just email this to everybody and we'll say that we were here? All right. Okay, so first of all, these are not all my ideas. I swiped a bunch of these from another attorney, but some of them are my ideas. So the idea behind what's in this list is that these are some concepts to think about when deciding how you're going to establish your pricing in the contract. So all of these would lead into some sort of agreement about how material prices will be dealt with. And even though it deals with material prices, labor could be a factor in this as well. All right? So the first one, which I don't think is a good idea, but it's on here, is that the subcontractor assumes the risk. Now, one of the things that you do in a contract, one of the purposes of a contract is to allocate risks. Who's going to be responsible for what, when, where, and all that type of stuff. So here, in essence, you take all the risk of material changes. So it's obvious why I don't think that's a good idea. Because I think if you did number one, that you're not going to get many jobs because you would want to build enough margin into it that you would hope that the prices don't change enough, and so your material price and your overall price is going to be substantially higher if that risk is coming to you, because you're going to price that risk into a markup on your material. So I think that unless this is a very short-term project and you have confidence that you could acquire all the material in advance, I don't think that that's a particularly good strategy. Any thoughts or comments from anyone on that one? Okay, the next one, this would be a great one from a subcontractor's perspective, right? Just throw it all onto the general contractor. Hey, if my price goes up, my price goes up. You're going to pay me whatever it's going to take. But I haven't seen any general contractors who are prepared to do that. And also, even though we're talking about subcontractor and contractor, this can work between contractor and owner as well. I have seen situations where owners have basically been willing to take on the price increase, mostly in residential construction, mostly on large custom homes, because they've just recognized that pricing is going to change. And so, but in that situation, a lot of times what they've done is that they've also, not only have they wanted to take on the material cost, whatever it is, but they want to strip out any markup on the material as well. Okay, so risk splitting is just the hybrid of the first two. You have some sort of an agreement about if the prices go up, this much of it, the increase is your responsibility, this much is my responsibility. If you wanted to go down those lines, that's fine, but I think you still do the same thing on the first one, which is that you're going to price your risk of additional cost into a markup. And so again, that wouldn't be something that I would foresee anybody wanting to use for a project that's going to go on for an extended period of time, but something that would be a fairly short-term sort of a deal. Okay, the next one, which, and so I haven't seen a lot of the first few, especially recently. The next one, this threshold, is where you have risk up to a certain point, and then if the price increases by 5%, you're just going to bear that risk. But if it goes over that amount, then the general contractor, the owner, takes on the responsibility for anything above that. Now, the way that's helpful on the subcontractor side is that you just assume that the price will reach that 5%. So you build that into your material pricing, so that you've got it covered with what you go with, and then if it goes over that, if prices go up by more than that, then the risk is over onto the general contractor or onto the owner. Does that make sense, or did I confuse you guys? So you wouldn't split your material price out necessarily separate in your bid, but what you'd have to do is you'd have to establish what what the prices would have to be for what 5% of the price increase would be. So if you say that however you did it, if you did it on specific materials or on materials in a gross amount, you don't have to put it in as a percentage. You could just say if once material costs exceed this point, or for this bid, then the amount of materials in the bid is $50,000. So if it's over 55, then that shifts. So something along those lines.
So, question for you on that. If we gave them a fixture price, say that we use our fixtures, and say, here's our fixtures that you've chosen, here's the prices for it. If it goes above this, can we put that in the contract?
Oh, sure, yeah.
Okay, this is not our problem. This is a problem that the owner or the general.
Yeah, and so it depends upon how much detail you want to get into.
Well, I'm just
right?
trying to get rid of the problem in question.
Yeah.
Because I don't care that I put my number in there at the beginning with that item and say, here's my fixture cost.
Yeah.
But if they go up, is that legal? And
Anything's legal. It's a contract. Well, so you can agree to anything as long as it's not illegal. An illegal contract is not enforceable. So if I hire you to kill somebody, Ralph, which I realize that's your plan for retirement, and that's not what you're doing professionally right now, but yeah, so that's an example of what's illegal, all right? So you can't have an illegal. So if you don't go out and kill the person, I can't sue you for breach of contract and say Ralph did not kill the person that I hired him to kill. Did I go dark too fast for everybody today, or no one can see Ralph actually being a hitman? I mean, I don't know which part of that. Yeah. I think Ralph would be a good hitman. I mean, I wouldn't suspect Ralph of being a hitman. Yeah. But I don't think that the Doppel wants to give continuing ed for just talking about hitmen in the plumbing industry. So yes, that is legal. Most of the time, you want to be most subcontractors don't want people to know the amount of their markup. So let's say that we're using this 5% figure, and your regular markup is whatever it is. I would add 5% to that markup, and then I would put the total amount in because it's got that 5% in it, and then say anything over this is yours, general contractor. Yeah.
I can see a problem with that, them not wanting, well, obviously they probably wouldn't want to sign into the argue, but like if you have a year-long job and you say your materials are this much, they might say, well, you wasted this. It's like a framer or something. At the end of the job, he has a pile of wood there, and he throws it away sometimes.
Yeah.
Or they might say you mismanaged your use of the material you had for budget. I saw a bunch of pieces of pipe cut in half.
You're supposed to couple those split pieces of pipe together.
Yeah. Well, I'm just saying, have you seen that issue, or you just bringing up different scenarios?
I haven't seen a lot of that one.
Okay. Would you see a problem with that, like a general argument in that fact?
What we've actually done is we've actually said, okay, then if they don't sign something of that nature, then I say, okay, I want my cost up front, so I can purchase my fixtures up front.
Yeah.
And then I put a price for the storage of the fixtures.
And that's what we've done.
And then I can store it or put it somewhere so I can salvage what they just bought.
Yeah.
Because right now, I can't convince anybody to hold it for a year. There is not a supplier in the valley that's going to hold it.
The purchase and store strategy is the thing that I've seen the most.
Yeah.
I've seen, a few of my partners do work with developers and with companies that work throughout the United States. And any of them that have large projects going on, either within the project site or somewhere that's not too far from it, they are finding a place to be able to store. And they are working with the general contractor and their subs to just try and buy as much as they possibly can. And they're doing that for two reasons. They're doing that to control price, but also because they want to make sure that on their long-term stuff, that they've got that in the works as much as possible and that things are going along. Like, for example, I know that based upon that conversation we had at my office and talking with some others, the suppliers are breaking, this may not be all suppliers, but a lot of the suppliers are breaking their customer base, down into groups. And so if you're high in their group, if you're like at the top of their customer list, then they're reserving, like, I know for a fact the concrete companies are reserving this. There are some companies that they are going to make sure that they have a reserve of material available for them, because it's folks that buy from them on a consistent basis and who've been good customers and buy a lot. They're going to make sure they have stuff for them. Then they have another group where it's, we'll get it to you quickly, and then there's sort of as soon as we've got everybody else covered, if we have anything available, then you're going to get it. So that's one of the approaches that suppliers are taking in order to maintain their customer relationships. And so the purchase and store strategy is that not only does it control pricing, but in many of those instances, they're buying it now. It's cash on the barrelhead, and so it's to be able to pay up front on the materials, and because if they're putting down the cash instead of paying on a 30-day invoice or something like that, then it increases the likelihood they're going to get what they want and have it in time.
Who's
Yeah, right.
liable for like theft in those situations?
Well, that's-
Stored on site?
Yeah,
Is that the contractor, is that the subcontractor, the owner?
it can be anybody.
I thought until it's installed, it's.
Well, so a lot of times, especially in commercial subcontracts, it's even when you have something installed in the building, you've still got liability if it gets damaged, right? You have to protect it and things like that. So really it's whatever works out in the contract. So if you do have this come up, then if you want to look at the contract and see how that's dealt with. Because one of the things that I notice quite a bit in subcontracts, and I bring this up with general contractors quite often when I talk to them about it, is that is provisions relating to the fact that the subcontractor has the risk of loss until final acceptance from the owner is usually the way that it's written. And so a lot of times it gets phrased in a very general way. And I actually use that in the conversation with the generals, because I'll say, okay, wait a minute. So it says my client has an obligation to protect the material from damage, theft, and a whole bunch of stuff. So I'll say, are you saying that my client needs to incur the cost of like security and of putting up a fence around the job? And those are kind of absurd things, but that's what I like to throw out there so that they think I'm stupid, and also because that helps, and also because it sort of shows that there's some room to be able to talk about it and gets them into the mindset of, okay, well, all right, we can clarify this. So, because and I've seen theft in there several times. And I just tell them, look, you guys are fencing the job, right? You're controlling the building. I mean, you don't expect every subcontractor. This is your form contract. You don't expect every subcontractor to be protecting this site against theft, do you? No. And you don't want to pay for that? No. Okay, so let's talk about what's really going on. And so then you can get into a discussion on that sort of thing. So similar to this is that in my mind, if this is going to be used, whether it's at the site or some other location, then if it's the owner who's doing it or if it's the general who's doing it, then they need to be responsible for theft. They need to be protecting that site, because they're the ones who are they're paying the cost of that and having that there in order to make sure that there's a place for things to be stored for them to use in their building. And so if someone's going to come in and steal it or what have you, then it's really on them to be able to do it. So I think you need to check that and make sure that they haven't tried to push that to you. And if they do, then you just say, so every subcontractor, you want us to put a dog in there? You want us to have some guy standing out there? We haven't even got enough people to do this work. We're going to find someone to do security. How many security people are you going to have sitting out there or whatnot?
So a lot of times in master service agreements, it'll say something along the lines of, this agreement makes every other previous or any other contract null and void, or
Yeah.
supersedes everything.
Mhm.
So say you have a master service agreement and then you come up with this idea where you do this and you write a separate little contract, but because it's a newer one, would that master service agreement still render that one null and void, or how do you get around that?
Yeah, so what you're talking about is like the integration clause or the superseding clause that's in the contracts. And so usually it will say, you'll have what's referred to as a conflict clause, which says that if there's a conflict between the plans and specifications and what's said in this agreement controls, or the plans and specifications control, you'll have something like that. So the integration clause that's in there is the case I was doing the trial on yesterday while I was up at my office, up at our office here, is actually deals with this. That gets into, I won't do a deep dive into a bunch of legal technical stuff. It's called parole evidence. The idea behind that is to cut off whatever discussions were before you sign that contract. If you come in with a subsequent job, then the reason for that integration clause existing goes away. So that's designed to stop someone from saying, hey, we had this from coming in after the fact and saying that a conversation you had before you signed the master agreement isn't reflected and the document needs to be changed. That's the reason that particular clause is in there, is to draw a line of what the agreement is and when, and to cut off anything that happened before. So when you come in later, most of the master service agreements will allow for like a work order. They have different terms for it that has the specifics for the project. So what you can do with that work order or that document that's the unique one for the project is that you've got the master agreement and maybe their general conditions and stuff like that are sort of like the base of your relationship with them. And you can specifically say in there that if you're going to have storage, and if this has something that talks about protecting and stuff like that, then you can in this work order say not only what your scope is, but you can also say in here, hey, the owner is providing a storage for materials. Subcontractors' materials will be pre-purchased and stored there. And the best way to do it would be to go back to the master contract and have the paragraph number that talks about the risk of theft or what have you. And so you would refer to that and basically say that doesn't control. Say like, notwithstanding paragraph such and such of the contract, the owner bears all risk of loss of materials stored. They're responsible for theft and things like that. So when you come in later and you do something along those lines, then that can override what's in the contract. Especially if you can refer back to the contract and say this clause doesn't apply to this job. And if it gets signed, then you're good to go. Anybody else? Okay, so this is hands down the most common thing that I have seen. I've also, so in a lot of instances, we have owners doing it, and it seems to be the owners that do a lot. It's not the one-off sort of stuff, but it's the owners who are consistently building on a regular basis and usually in multiple locations and have sort of a construction management staff within their business that are operating their own locations. For the owners who don't build as frequently, then it seems to be the general contractors are telling the owners, hey, look, as a price control strategy, we should have a place where everything gets stored. And so instead of the owner running the storage, it's more of the general contractor that's running it. But same thing as far as wanting to put the responsibility on them for safety and management and control of location and stuff like that. Okay. The next one that's on here, I actually haven't seen, other than seeing this on the list when I was reviewing, I haven't seen anybody that's indexed their materials to the New York Stock Exchange American Steel Index or anything like that. But I don't represent any steel fabricators, and I'm not aware of, there's enough diversity within the scope of, within plumbing and the other subcontractors I represent that I don't know that there's an index out there that you could really rely upon. So that may work for the steel guys, but most materials, I just don't think there's anything out there like that. Is anybody aware of something? Okay. The freeze, the parties agree to a predetermined cost for materials in question. The price is not subject to change regardless of price fluctuations in the market. That's fine if you want to use that. So, but to me, that's not a huge difference from subcontractor at risk from the very first one. If you do a freeze, if it's just like, okay, well, these are the prices and we're not going to change the price. If I wouldn't sign a contract with that in it unless there was a termination for convenience clause that was also in there. So it's so that the commitment is, okay, that's fine. If that's what you want us to do, is you don't want us to be able to change our price at all, okay, we won't do it. But as soon as our price is no longer the price, so we're not going to, if the price drops, that's great, we'll make a profit. But if it goes up, then we can terminate for convenience. Because you can't, we're not going to agree to keep doing this job at the risk of subsidizing your construction project for you, right? So I think you would have to put there would have to be a termination for convenience clause in the contract, so that you could essentially say, okay, well, we've got this price freeze in here, but we can come back to you and tell you that that's just not working out for us, and then we're done. You pay us through that date, and then you have to go find somebody else to do it. But we're not in breach of contract. We're out of here. I'm not optimistic that anybody's going to sign a contract that says that. But if you do see something along those lines, then give yourself a termination for convenience. Does everybody understand the difference between termination for cause and termination for convenience? So when I'm advising, when owners of companies building warehouses in Nevada take my advice, they put termination for convenience clauses in there, and when they don't take my advice, they leave them out. We have a client who sent me their contract with the general contractor, and it was pretty sparse, and it had a termination for clause, but not a termination for convenience. And I went through and edited it. I added a termination for convenience, and I said, you've got to have this in here. There's a lot of economic volatility. You're going to want this in. Guess who didn't keep it? Exactly. Guess who got a call from their corporate office about 6 weeks ago, and they said, we need to stop that project. We don't want to move forward with any projects at this point. That client. And they said, what do we do? And I said, well, did you guys keep the termination for convenience clause in there? No. The general contractor didn't really like that. Sure they did. So I said, okay, you got to negotiate your way out of the contract. So termination for convenience is where an owner, and then we see these in the subcontracts quite a bit. Termination for convenience is a clause in a contract that says that the owner can stop the project at any point, basically, and not be in breach of the contract, which means that they don't have liability to the general contractor, or if it's in the subcontract between the general and the subs, the general doesn't have liability beyond whatever's agreed to in the contract. So it's a way of, like, if interest rates go up, or you have strange economic conditions, or something else like that, for whatever reason the owner just decides we don't want to go with this project anymore, they can terminate for convenience. Now, in order to be able to enforce a termination for convenience clause, there has to be a commitment to pay what's owed up through the time of termination. So it's not like you can terminate and walk away from it and not have any liability. You've got to pay for the work that's been done. But other than paying for the work that's been done, the owner doesn't have any forward-looking liability for lost profits or things like that. Make sense? So that's termination for convenience.
Does that include stored material, or like?
Yeah, so if you've got stored material that they've paid for, or that you've bought but they haven't paid you for it yet, then yeah, for sure. So when you're looking at a contract and you see a termination for convenience clause, know that those are enforceable, they are legal, but then look at the things that it says that you have to be paid for. In a subcontract, it will usually say that they need to pay you for your labor and material through the date of termination. And so if you've got storage on site, then you'd want to make sure and add in there for stored materials, or just to be careful. But look at that very carefully and make sure that whatever's said that they're going to cover really reflects what you would expect to be paid at the point that someone just comes in and says, okay, we're hitting the pause button or what have you. So that's the key on those clauses is making sure that what they're obligated to pay you reflects what you would actually expect to get paid for at a point in the contract where they just say, okay, we're terminating, contract's done, we're out of here. A termination for cause is where someone has actually breached. So you terminate the contract because they've failed to do the project on time, failing to pay for materials, all those things that you see in those lists. So it actually has to be a violation of the contract to do a termination for cause. So that's the difference between convenience and cause. You can also have a suspension for convenience, which goes to the idea of a pause, whereas, hey, look, we're not terminating this. We're just not in a position to be able to proceed with it. And so because we're not in a position to be able to proceed with the job right now, we're just going to stop. Yeah.
Should that include increased price if it started back up again?
Yeah. So if you see a suspension for a convenience clause, then you've got you're going to want to have demobilization, remobilization. You're going to want to have some price flexibility, stuff like that. I did have a situation come up it's actually about 10 years ago, I guess, where it wasn't a suspension for convenience, but it reflects what goes on in the situation, which is that the work that there was a death on the job site. It was a government job, and a brick mason fell off some scaffolding and died. So the government shut down the job while they did their investigation, and the general contractor told my client and some of the other subs, keep a couple guys out here, we think we're going to get going pretty soon. So they didn't demobilize. And after 8 months, the government still hadn't given the okay for the job to go. And it actually wound up took somewhere between 12 and 18 months before they got going with the project again. And so we were going after demobilization and remobilization expenses. We were also asking for a change order related to the time that we had people down there not doing anything. So so think about that if you see a suspension for convenience. Any other questions about that? So then you've got this guardrail one that's got a high and a low. Remember up here on the freeze, I said if you did that, you wouldn't want to put a floor in it. So the guardrail idea is where you have a floor. So as long as it's within there, then you just go with it. Again, I haven't seen that. I understand the concept of it, and I think that there may be some projects where that can make sense, but I think generally speaking that that's not the most desirable way to go. This kind of goes to Ralph's question earlier. The combination one is it's that these are ideas. You can agree to whatever you want to agree to as long as it's not illegal. And so, depending upon the nature of the project, depending upon who the owner is, who the contractor is that you're working for, your experience with them, your confidence in them, and things like that, you can mix and match and do whatever you want on these things so that it fits what's going on with the project. The key, obviously, is that if you have a different deal on every job that you do, then you start to create administrative burden and administrative management expense for yourself that may not make doing a lot of different things on a lot of different projects viable. So keep that in mind as well. That if once you agree to it, it's an agreement, and if it's tricky and weird and too hard to manage, then that in and of itself could make things difficult. And so don't overlook the administrative complexities of some of the things that you can do here. Okay, unit pricing. I have seen, so in addition to, purchase and store, especially on commercial projects, I've seen that a lot. Unit pricing. I've seen this, I haven't seen it as much because it's another way of doing this second one up here, which is where you push the risk. So essentially what you do on unit pricing is you just say, well, it doesn't matter we're not giving you a price for material now. This is the material that we're buying, and you're going to pay like a cost plus, which people are going to want to negotiate with you on your plus part of it, right? But if you can work something out like that where they pay some margin on whatever it costs you to bring it, then that's the idea of what you can do with the unit prices. You just pass the cost of materials off to them. And essentially you're putting some profit margin and then some delivery related expense on top of what you're buying it for. Or if you can get, if without disclosing the margin, if there's the way that you can do it, then you can just have them pay on a unit price basis.
We have that a lot on these big custom homes because the homeowners haven't chosen their fixtures.
Yeah. Well, a lot of times on custom homes, well, even on any homes, but especially on custom homes, do you give them an allowance?
Yeah, no, we usually just, we guess on a price.
Yeah.
But we put in there a cost plus markup.
Okay.
Because there's no way, what am I putting in?
Right.
That could be 20 grand or 100 grand.
Especially with some of these faucets and stuff that they're getting from Europe nowadays.
Maybe not as many, right?
Well,
Lead time.
you would need, okay, the rich just know where to go get it. That's the
I know, yeah. Oh no, are you suggesting there are different economies for different people, Ralph? I mean, what?
Yes, I'm sorry there is.
But then again, that goes back to
Now you're finding that out.
that goes to the whole hitman. Yeah. My plan's in 1965. I have to spin the prop and push the plane and get it going, and then jump in before it takes off without me.
Now you've seen the other side of it with the plane next door to you, that's the jet that took off and got there before you even got off the runway.
Yeah. Yeah. But that's why when you retire, you're going to be the guy I know.
Well, there's another one that I want you to see if you've got on here, and that is in these,
That's the end of my list.
the big project
Yeah.
where we're heating the buildings. So warranty on the equipment starts when we start it up.
Yeah.
And also cleaning, and
Yeah.
especially if they're using it for, in the heating world, we have to clean them after they sheetrock.
Yeah.
Because their construction dust and all the other stuff that goes through on a fan coil, those are just disastrous.
Yeah. So hold on to that because I have another thing to talk about along those lines. So we've already talked about this, and I was going to take your first comment about the fixtures for the extremely wealthy people you do work for. On the idea of what phasing is here. So phasing is, you could do it as underground, rough, and trim, but so you can. The idea behind phasing is that you put the project into foreseeable horizons. So you can give a base amount for each phase, ultimately to be determined when you get to the point that you're ready to do the work and get the material. And then that's sort of the idea of, we'll bracket it for you right now. And so we anticipate it's going to be in this range. But when we get to that, then we'll establish a final price when we know what the price is going to be for the material at the time we do the work. That's the idea of phasing. Because if you have a level of, if you can break it out and have purchase points, then you can use that. I've seen a little bit of that, not a ton. Like I said, the purchase in the store is the most frequent one. Okay, so any other questions from anyone? All right, so warranty. On the commercial end, the warranty starts. Some of those manufacturers will give an extended warranty, but there has to be a price for it. And the general contractors know that if you're heating the building and you start that stuff up, they know that the warranty starts. And so when you're working on the contract or on the bid or what have you, there's a lot of warranty stuff that doesn't get negotiated, but if you're going to put in a unit like that, the warranty on that unit has got to be part of the negotiation, because if they're going to expect that unit to heat the building while they're doing all the work and you've got all that gunk going through it, then they know and you know what that means from the manufacturer's end. And so they should be taking it up with the owner and working on that stuff. But as far as getting it dealt with, if the owner wants to pay for an extended warranty or the owner understands that's when the warranty begins, and if they also understand that you're going to have costs associated with cleaning it and getting it ready to go once the construction process is over, I think you just got to build that all in.
A lot of some of these guys are just saying, "Oh, heat it with something else. I don't want to use my equipment."
Okay, so if they say that they don't want to, if they want you to heat it with something else, then
That's usually on the general.
yeah. So then, can you put like an alternate in your bid for alternate heating if they're not going to use that? Yeah.
We just have that conversation in these bigger jobs because of
Yeah.
bringing that up for anybody else.
Yeah, it's there. The generals know it. The generals understand it. Yeah, and but it's that, like I said, that's a warranty issue that you definitely want to make sure you get dealt with up front, because it is a problem. In fact, if
Say that the LDS church is one of the biggest culprits for that.
well, just don't stop paying your tithing for a while, Ralph.
Just say that they love to have you heat their buildings, and then they don't want you to clean your equipment after. Well, they do, but they want you to clean it, and they want you to heat the building.
Yeah, I know. I thought suing the LDS church would keep me out of certain responsibilities, and it didn't work. No, sadly. Okay, let me throw. So I think you guys, this will be interesting to you. I have a case right now for a mechanical contractor, and some of you may know about it if this person has had conversations with you. But unlike Dennis, I'm not going to reveal this person's identity. So, and it's not Dennis. We were just talking about you before you came in, Dennis, that's all. Okay, so this involves a fluid line from the boiler in the building. So it was tenant improvements. It's a building that's already been constructed, but they hadn't improved all the space, and so they were improving part of the space in the building. So there's a, I'm going to say it wrong, but basically there's a hot fluid line that ties in from the hot water, not the hot water, but the glycol, yeah, it ties into the boiler. You know, you got to go out to the VAV box, and then you got the return line, right? How did I do?
Supply and return.
All right. So am I doing okay? All right. That's as good as it gets. It took me like 20 years working with this association to be able to say VAV box and all that sort of stuff. So, there is also a cable tray. So after those lines got put in, for the data and some other stuff, they ran a cable tray, and the cable tray runs underneath those fluid lines all the way down the main corridor. Is anybody foreseeing any problems here? Well,
Getting the cables wet.
yeah, so then the cables are all in there, like 300 cables. And as per specifications, my client was required to do an air test on the line and to do a water test, pressure test on the line to check it for leaks. It's right in the specifications. So, on the water test, there were 2 leaks. And those Cat 6 data cables got wet. Do you guys know what happens if data cables get wet?
They say it voids the warranty.
Yeah, so they say it voids the warranty. So they ripped out all the cables and replaced them, and they want over $100,000. And so here's my question to you. If the specifications specifically say that you need to pressure test it with water and there's a leak, should the contractor who put those lines in be liable for anything that's supposedly damaged by that leak? Now, we got turned off and everything got dried off, okay? But you guys, this is your business, right? So if that's you, the contract requires you to do it. I mean, that's an industry standard sort of a thing to do, is to pressure test it with the water, because you don't want it leaking with the antifreeze, the heating fluid, the glycol, right?
Which is why you would air test first and then
Yeah.
put the glycol in.
Yeah.
So
So do you think you should be responsible if it leaks and it gets on something?
So the pipe was installed first, and then the cable was installed underneath.
The tray was put in and the cable was put in underneath it.
Underneath it after it.
After it was in.
Correct.
The mechanical installed first, the cable came in second.
So isn't there a clause that says that you accept the person's work before you, if you install after, isn't there something that says that you accept the work that's been put in before?
Well, that's what I'm trying to get you guys to think about, because I'll explain to you how you're approaching
I
it.
know what job this is.
Yeah.
I heard about it.
Okay.
To me, it's insane if that cable is that precise and needs to be protected. It should be installed differently.
Yeah.
It should be in a sealed environment.
Yeah.
I mean, we all know, you go into a room after the fact, that cable is strung everywhere from hell to Reckless, basically.
Mm-hmm.
And here I find out, I heard about this situation.
Yeah. So I'm asking you the question because I want you to think about it. And so, because there are some different ways that we're approaching it, but just your gut reaction. If you've got to pressure test it and you've got to run water through it to pressure test it, why is it that they want it pressure tested for leaks? That's what it actually says in the specs. Pressure test the system with water for leaks. Why? To see if there's a leak, right?
Is that defective workmanship on
Well, that's what they're trying to say.
Well, I think the guy installing the cable tray should assume the risk of putting it right underneath the pipe and having it.
That's a nice job. I like that, Dennis. We should make you into a lawyer.
Industry standard, have you ever installed a job without a leak?
Right.
While you test, right?
Right.
So industry standard says you're gonna have leaks, that's why you're testing.
Yeah.
So if they're assuming that you're gonna have leaks, then why are they installing the
They
tray?
gotta buy some cable
In
to
the cable.
handle getting wet.
Well, it's the general contractor who's making the claim because the general contractor paid to put the cable back in. Now they're saying that their own subcontractor has liability back to them. Actually, it's their insurance company. Okay. Here's some of the stuff. So first of all, in the subcontracts, and this goes back to something what we were talking about earlier. That's why I'm asking you the question to get you to think about it. In the subcontracts, it says that the subcontractor is responsible to protect their work until final acceptance. So if I'm responsible for getting for putting in the cable and the cable tray and stuff like that, my contract says I'm responsible for protecting that, and there's a leak in a fluid line above my cable. Is that on me or is that on the guy whose fluid line leaked? It's on me for not protecting my stuff, right? So that's one of the things that we've said on it. The other one goes back to like Eric's comment, which is that it's not just because the line leaks doesn't mean that the work wasn't done right. That's why we were required to do the test, was to check it. It's part of the process is that no matter, even when you do your very best, there can be problems, right? The other aspect of it is this.
Couldn't that also be a scheduling conflict then? Because provided the mechanical contractor had enough time to put it on pipe, and assumedly he would be testing right away.
Yeah.
So they moved the next trade in before they were able to finish their job. And if they had scheduled that better, that could have happened.
Yeah, that's a possibility. That could be. The other one is the choice of where to locate it. If they could have located it someplace within the corridor where there wasn't a leak.
For sure.
The other part is this. So remember, you guys have seen these, you've seen the Cat 6 cable, right? You guys all know what I'm talking about? It's got the rubber on the outside. If you yeah. And so none of those cables were hooked in when this happened. Not a one of them. So they ripped out, at the owner's insistence, the general contractor tore out all of the cables and put all new cable in. How likely is it that any of those cables were damaged? Yeah, it's about 0, right?
Some of those have probably had water on them of some kind.
Sure. So what they're saying is that you have to pay us 100% of the value of these cables, which, by the way, we told them don't throw the cables away. Keep them. But guess what they did? They threw the cables away. So there's no evidence that any of the cables were damaged. The owner demanded that they be torn out and replaced because any moisture on those cables voided the 20-year warranty. So what's the real financial loss to the owner if the cables themselves are not actually damaged? It's the risk of sometime over the course of 20 years having to replace a few, possibly, of those 20 cables, right? So it's like the present value of a future warranty claim is what they've lost. That's going to be a whole lot smaller than the cost to replace all 300 cables right now.
Even if they made them do a bond or something.
Yeah.
In case 10 years from now.
And that was all in our correspondence. We were like, look, you guys are out here. First of all, whoever put that in had a responsibility to protect it. It's not a mistake for us that there was this problem, and they don't need to be replaced. There's no evidence that any of them are damaged. So it's just the value of what a warranty claim might be over the next 20 years. And then the other thing I told them in the letter was, I said, as far as we know, 20 years from now, they're not even going to be using data cables, right? I mean, the speed of technology, it could all be wireless. So how do we even know that in 20 years, you're still going to be running off those data cables? Yeah, Lawrence?
What's the definition of moisture?
Well, it's whatever the judge wants it's whatever my client needs the judge to say it is.
It says moisture, does that mean physical water, or is that 30% moisture?
Well, yeah, but the other thing is this. It's not just that line getting wet. Basically, if you look at the warranty, anything that gets on that line, anything that gets on it would void the warranty. Well, there's a bunch of spackling that was on it. They put it in before they did the sheetrock, and so there's a bunch of blotches of mud from the spackling that are on it. Now, last time I checked, that stuff's wet, right? What has the potential to damage that cable the most? A few minutes of some water from a test in the line, or some spackling mud getting on there and completely drying out while it's on the cable, right?
Plus, they pull that humidity,
Yeah.
they pull those cables, they're all over the floor when they're pulling them, you know, we're stepping on them, tripping over them, you know, it's insane.
That's a good point. I got to put that in my notes.
Yeah, they also have humidity, they're not just up in the air to start with.
Yeah, humidity.
They're everywhere in our weather.
There is a project that was in Hawaii that humidity's at like 80%.
Yeah.
I'm sorry, 80% humidity is gonna ruin a cable faster than.
Oh, for sure. Yeah, I mean, it's there all the time. So the reason I bring that up is not just for the example, but also to just kind of come back into, because we were talking about protecting and theft and some things like that. So I wanted you to see an example of, so when you're looking at a contract and it talks about protecting your work, that this will kind of jog your memory on some stuff and how it has meaning. And we've actually found cases, decisions in other courts where the courts have gone in and looked and compared the contracts and said, hey, look, this is what the contract said, and they have responsibility for it. So it's an agreement, right? That's what they agreed to do. We can talk all day about what we think it should be, but we can go and actually look at the contracts and see how it was done and who agreed to accept it. Guess who it was? It was a cable installer. Are we publishing this, Dave? Is this going out on the internet?
Yes, don't say it.
Actually, it is public information because it's filed with the court, but I'll tell you guys later.
I just finished a job with that contractor at American Fork at a hospital.
Did you?
I told my guys, you'd be dang sure do not get any cables wet on this job.
Yeah. Yeah. Okay, any other questions? It's 11:58. I'd tell some jokes, but
We got a good lawyer joke, come on.
a good lawyer joke. There are no good lawyer jokes, Ken. Thank you very much. Any general questions about that you guys have on anything that's going on you want to ask? I'd be happy to answer. If not, if everybody's ready to be done and head out, it's 12. It's like 2 minutes to 12.
Well, the flight is still eat, so whoever has a spouse is out and about, then you have to wait until 12:30.
I don't think anybody seems too concerned about that. All right, well, thanks for your questions. Thanks for coming down here and taking time. Thanks for the opportunity to be able to do everything I do and enjoy working with the association. So let me know if anything comes up.